the tragedy in Colorado, so many innocent lives taken at a movie theater. Tomorrow, the accused mass murderer, James Holmes, is expected to be charged with at least 12 counts of first-degree murder, plus a slew of other charges related to that massacre. But America will not be able to see it, because even though we saw this when he first appeared in court, the judge has said no cameras tomorrow. The judge also expanding a sweeping gag order to not allow information to be released from the university that Holmes attended, information that could certainly be evidence in the case. Joining me now, our legal panel, Joey Jackson, former prosecutor and criminal defense attorney, and Robert Schalk, defense attorney and also former prosecutor. Great to have both of you here.
Good morning.
You know, I'm a little disappointed, not for me, but for the victims, Joey, because some of them made their way to court, some are still in hospital, and they would like to see the alleged shooter. They would like to be a part of this, and if they can't, they won't. Is that fair?
You know what? It isn't, but it's evaluated upon who it's fair to. And I think what the judge is doing here, Jamie, I think it's overly broad, really. And I'm hopeful by the time of trial it's retracted and that we're able to see the totality of the case. I think what the judge is concerned about is the fairness to the defendant at this point, because you know our judicial system. This is going to be a death penalty prosecution. At least it's expected that that'll be the case. And you know, Jamie, Bob, the reality is there are going to be appeals aplenty in a death penalty prosecution as is. So to the extent that you can limit those appeals and not make appealable issues where they don't belong, in that sense, it protects the defendant's constitutional liberties.
At this point, the gag order was expanded because there was reportedly a leak about information that came into the university he attended, a supposed notebook that detailed potentially what he was going to do. First of all, is that admissible?
Well, it would depend. The judge is going to have to take a look at it, probably in camera. The attorneys will ask that he take a look at it outside, anyone else's
Privately.
eyes. Correct. And obviously the prosecution is going to want to use it. The defense isn't. But the thing that the judge is trying to do in this unconventional gag order is he wants to be the filter of the information. He wants to see it first, because as Joey said, he doesn't want any information to be out there that potentially would be inadmissible at trial, which potentially would be in violation of Mr. Holmes's rights as a patient with a doctor or at a school. He would need to release those documents to whomever's looking at them under normal circumstances.
But you know what, in Florida with the Stand Your Ground law and the Trayvon Martin murder, the judge is the first arbiter of the facts. Yes. The judge does make a decision before the case reaches the jury. That's not the case in Colorado, as far as I know. This judge doesn't necessarily decide guilt or innocence.
Correct, but he decides the admissibility of evidence that the jury is going to hear to determine guilt or innocence.
That part's
and
true.
As Joey said, the last thing that anyone wants to see in this case, and again, a presumed death penalty case, is to have the jury hear evidence or come in with predisposed notions as to what they think the evidence is, and have this go up to an appellate court and have any conviction overturned.
But how do you pick a jury in this case, Joey? The whole world is talking about this.
It's so true, and I think not only as it relates to this case, Jamie, but I think cases in general. We're in an internet age. We have Twitter, we have Facebook, there's so many ways for people to get information, and I think there's always been a debate as to whether cameras should be allowed or they shouldn't be. You all remember the case Florida versus Chandler, 1981. Over 30 years ago, the Supreme Court said you can allow cameras. It's not offensive to the due process rights, but at the same time, you have to limit it and you have to protect the integrity of the judicial system.
I don't see how it prejudices this defendant or potential jury pool when this hearing is just the reading of the charges.
Right. I agree with this time, but you may want to limit it with pretrial hearings and any discovery documents or any arguments that are made, because you don't want the people who watch Law and Order or your people who watch CSI, who are going to be your jury pool, to start making decisions of, well, he shouldn't have done that or he should have done this, and then they're the people who are being questioned. You have to make sure that the only time I would say that you're going to see cameras is once that jury is sworn and impaneled. I think you'll see cameras in the courtroom again.
I feel like the judge could always say approach the bench. Let me ask you about that notebook. Sure. If, in fact, James Holmes, the defendant, was seeking psychiatric help at the university and wrote down something that posed a warning that there would be harm.
Yes.
Can it be admissible in court by the prosecution if he doesn't take the stand and can't be cross-examined on? How do you cross-examine a notebook?
Oh, it's a great question. But here's the issue, though, Jamie. In the event that there is a insanity plea, insanity defense that's proffered, remember now, there has to be an opportunity for the prosecution to rebut that. How do you rebut the claim of insanity but looking at documents which say you're insane? And therefore, if you open the door as a defendant in a case to your psychiatric history, the medical evidence and records which evidence that psychiatric history and insanity become evidence for all to see. And so I think we're going to see it.
So this defendant proffered a so-called potential manifesto describing if it seems rational. Is he insane? If he addressed it to anyone other than that doctor, has he waived his privilege under the doctor-patient?
Well, of course, yes. The same way you would waive an attorney-client privilege. If you tell your attorney something and there's a third party there, your privilege is waived, and that person can come in as a statement of the defendant to come in and testify against you.
And if that's the case, we may get to see that notebook at some point.
Yes.
Who knows? Gentlemen, come back. We have a lot to talk about on this case.
Pleasure,
and again,
Jamie.
my heart goes out to all the victims of the tragedy.
Definitely.
Eric?
Thanks, Jamie. Now to the Fox News voter fraud unit. And as